This is Dust, Documents and Diamonds, a podcast about history, researching history, and the joy of finding diamonds when we search the archives for the dust of past lives.
If you are a dissident who wants to uphold the law while breaking unjust laws, what do you do? Especially when you're on trial for breaking a law you don't believe in. This episode is about some examples of what you might do from Catholics in Elizabethan England. In London in 1590, two English men were on trial for treason. They stood accused of one of the archetypal sins, but their indictment was framed on a fairly recent law, a statute which came into force in 1585. In defiance of this statute, each of them, and I quote, "being born in the realm of England, was made priest since the feast of St. John Baptist in the first year of the Queen's reign, by authority derived from the Pope of Rome at Leon in the parts beyond the seas, and afterwards did contemptuously come into this realm of England." And that is from a contemporary report of their trial. Between 1585 and 1603, that is the rest of Elizabeth's reign, 94 men were executed for this crime, of having been born in the Queen's dominions, ordained a Catholic priest overseas, and re-entering the country. All priests had to be trained at colleges set up abroad, since such things were of course illegal in England. Another 22 priests died under this statute from 1603 to 1640 under Kings James I and Charles I, and a further 21 from 1641 to 1654 during the civil wars between King Charles and Parliament, and under the republican regimes set up after the king was defeated and killed. Some other Catholics died under other statutes, but the 1585 law against priesthood accounted for the largest share of Catholic martyrs. At this particular trial, both indictments were factually correct. Anthony Middleton and Edward Jones had studied at the English College in Rouen. They had self-evidently returned to England, Middleton making the journey on the 28th of October 1588, and Jones on the 10th of July 1586. Their cases were similar, but their responses were strikingly different. Edward Jones acknowledged that he had indeed been ordained and entered the realm, but yet he was not guilty of the indictment as read because, he said, "I came not contemptuously into this realm, but to save souls. And whereas there is a penalty appointed for the not observing of a law, as do this or pay this sum of money or suffer this punishment, there is no contempt." The judge asked if Jones were therefore contented to suffer the penalty, which is to be drawn, hanged and quartered. Jones answered, "Yes." "Well then," suggested the judge, "he had better, quote, confess the indictment, i.e. plead guilty." "But no, that will I not," Jones answered, for that I came not contemptuously." Eventually Jones pleaded not guilty. The jury convicted. Anthony Middleton's response was both similar and entirely different. "I must not deny myself to be a priest made, as is contained in the indictment," he said. "And although I came not into the realm contemptuously, yet," said he, "that is nothing material, for in respect of God's laws I contemn man's law, for melius est obedere Deo quam homini, that is, it is better to obey God than man. Therefore," said he, "I am guilty." Both Jones and Middleton were priests, both were condemned under the same statute, and both were executed. In the view of the Catholic who wrote this letter which described their trials and deaths, both were martyrs. But standing side by side at the bar of the Old Bailey, they dealt with this clash, this disjunction as they saw it, between power and authority, between human and divine law, between what was right and what was legal, in very different ways. So let's look quickly at the context of this trial. With their opposite pleas and identical circumstances, Middleton and Jones stand for the complex dilemmas that arose from a devastatingly simple situation. We know of no case before 1641 in which a prisoner was acquitted of this indictment under the 1585 statute, although not all those condemned were actually executed. And in all those cases, as far as we know, the accusation was correct. That is, the defendant was, in fact, an English subject and a Catholic priest. But that is where the uniformity ends. Defendants at these trials actually responded in hugely different ways. Some few, like Middleton, pleaded guilty. They'd done it and they'd do it again. Others, like Jones, grappled with the philosophical problem of a law which contradicted, as they saw it, the principles of just law. Some rejected the whole rigged system by refusing to plead, and some engaged in what seemed like serious attempts to actually get acquitted. Today I'm exploring one or two of those cases and what they tell us about law in Elizabethan England, about law, about religion, and about how Catholics defended themselves against a statute that seemed written to preclude defence. It seems fairly simple. Maybe you were right to break the law, but it's fairly obvious that there's a law and you broke it. But for many Catholics, that just wasn't good enough, and it wasn't simple at all. Jones's not guilty plea illustrates one way of tackling the dilemma. Let's just think for a bit about what it meant. We've seen that Anthony Middleton declared himself obedient to God's law and guilty under English law. He thereby indicted the whole English state as standing opposed to God. His confession of the indictment was even more defiant than Jones's denial of it. Jones, on the other hand, wrestled with the words of the indictment to find a way in which he might defend his actions and yet remain within English law. The statute decreed a certain penalty for a certain action. Since he had chosen to commit that action and was willing to pay the penalty, he had honoured the law. Catholics insisted on dividing the Crown's jurisdiction in worldly matters from the jurisdiction which it claimed in spiritual matters, ever since Henry VIII had broken with the Church of Rome. Edward Jones took this to the utmost. He seems to concede that the Crown had a right to execute him for his actions if it chose, but he might lawfully prefer to save souls, as he put it, than to stay alive. His defence, explicitly accepting death as the outcome, made refuting guilt its own end. He submitted to the law in order to disprove the law's claim that he was a traitor. Jones's stance here was echoed by another priest, Thomas Garnet, who was tried and executed in 1608 during James I's reign. There are several accounts of his death written at the time. One of them reports Garnet saying that he was no traitor because, and I quote, "He who is obedient to his prince is not faithless. The prince issues a command. If any priest returns to England, let him be slain. I have returned here, and I consent voluntarily to be put to death. Thus I give my body to Caesar, and my soul to God." Incidentally, Thomas Garnet is distinguished from the other priest, Henry Garnet, who was actually his uncle. But they are different people with different stories. Anyway, so by indicting priests officially for treason, the English government was arguing that it was not conducting a religious persecution. These were executions of criminals who had violated their lawful allegiance to the sovereign and the nation. English Catholics were always concerned to refute this accusation, to show that executed Catholics were indeed martyrs. The really interesting point here is that Jones and Garnet each did this by characterising his entering England as an action for the sake of religion, but his death as an action of faithfulness to the English crown and Commonwealth. They cut the ground from beneath their opponents' feet by agreeing that the statute demanded their deaths as traitors, yet emphasising through those very deaths that they were not traitors. Through the law and through law courts, Catholic dissidents might express and vocalise the interplay, the symbiosis almost, of their faith and their national identity. They also challenged the right of the Elizabethan regime to define either true religion or true Englishness. And they threw up a lot of interesting questions about what law meant in Elizabethan England, how law courts worked, and how people thought they were meant to work. The first question addressed to a defendant at trial was, how do you plead? There are supposed to be two answers, guilty or not guilty. But for some Catholics, how do you plead was an open-ended question. How do you plead when you don't believe in the law you've broken? Part of what Edward Jones's unusual defence did was to address this problem of how to plead, where the facts alleged in the indictment were correct, but you believed yourself innocent of the crime they were declared to be, i.e. treason. A not guilty plea was arguably a lie. A guilty plea, yes, guilty of treason, would seem to concede the whole debate about treason or martyrdom to the government. Middleton carefully separated God's law from man's when he confessed the indictment, but even with this understanding, most Catholics could not bring themselves to answer guilty to an indictment with the word treason in it. This is why a number of priests doggedly argued the point, trying to find ways of pleading that separated their actions from the label given them and challenged the statute itself. Robert Southwell, the Jesuit priest also remembered as a talented poet, told his judges in 1595 that he was a priest, quote, but no traitor, nor can any law make it treason to be a priest. Not should not, but cannot. Like Middleton, Southwell asserted a hierarchy of law, which came from a Catholic philosophy. Human laws are invalid when they contravene a higher, i.e. divine law, even if the authority making them were itself valid. Southwell was also insisting on the status of priesthood. Appointed by God, it could not be outlawed by human authority. But he also asserted something about treason, that it was not a mere legal category, but a moral category, with, therefore, an objective nature which human laws could not just change at will. Priesthood was no more treason than circles would become square just because England's Parliament made a statute declaring them so. But priests who pleaded like Southwell did not simply assert that guilt under the statute was irrelevant to guilt before God, placing English law in opposition to divine law. They seemed to accept the court's authority while denying the validity of this specific law. In a sense, the court's validity, and therefore the valid authority of the English state, made it wrong to state in that court that something was treason which was not. To assert limits to a source of authority is to acknowledge it. The court would not allow a prisoner to argue definitions like this. Southwell in the end answered, not guilty of any treason, and this was accepted as a not guilty plea. But there was another option. If either a guilty or a not guilty plea was problematic, one could refuse to plead at all. I want to look now at why some defendants made this choice, because it was a daring one. Obviously, law courts don't want defendants to refuse to plead, because you can't have a trial without a plea and you can't enforce the law without a trial. Since the Middle Ages, the English legal system had developed a method for discouraging this defiance, the grim penalty called peine forte et dure, long and hard pain. This, as those who've seen Arthur Miller's The Crucible will know, involved laying the prisoner under a wooden door and piling on heavy weights to the limits of his or her endurance. It was not meant to be a method of execution outright, but of torture to produce compliance. Only a few prisoners took this course, and only a few of them held out to the point of death. Peine Dieu applied in cases of capital felony, murder, robbery, major theft, and, after 1585, helping or assisting a Catholic priest. Refusing to plead would happen at the first stage of a trial, the arraignment. Criminal trials usually went in two stages. First, the indictments of all prisoners at a particular session were read before a grand jury, and prisoners entered their pleas. Then the grand jury voted on whether to pass the indictments, basically on whether there was a case to answer. After that, those who had pleaded not guilty went before a trial jury who would decide their guilt or innocence. Of course, those who pleaded guilty could be sentenced forthwith, and those who refused trial stalled the course of law before they ever met the trial jury. The first Catholic who challenged the validity of the 1585 statute by refusing to plead was in fact charged with the felony of assisting a priest, not the treason of being one. She was a woman named Margaret Clitheroe, and she died under Peine Dieu. More about her some other time, perhaps. But the thing is, though she's sometimes been treated as a strange case among Catholic martyrs, she was actually a trendsetter in a small way. Because after her, a number of Catholic priests also refused to plead. I think the reason historians haven't noticed this so much, as the Clitheroe case, was that these priests were charged with treason, and in treason cases, refusal to plead was taken pro confesso, in place of a guilty plea. It thus led to automatic sentence of the penalty for treason, death by the notorious hanging, drawing and quartering. Thus, because for priests the outcome sort of looks the same, as it were, as if they'd pleaded and been convicted, it's just less conspicuous in the sources. But why did they do this? What were they trying to say? One reason was that to plead at all was to acknowledge the state's right to make priesthood, or the harbouring of priests, a crime. This, it seems, was behind Margaret Clitheroe's statement: "Having made no offence, I need no trial." She maintained that the law she was indicted under was contrary to God's law, but instead of concluding that it was therefore right to break it, Clitheroe maintained that it is therefore not a law at all. There's no offence to be guilty or not guilty of. Thomas Bullocker, a good 60 years after Clitheroe, seems to argue similarly to her when tried for his priesthood in 1642. He first stated, "If by guilty you understand something harmful, pernicious, or something which is constrained to judgment, I deny forthwith that I am guilty, although I do not disavow that I am a priest." And I'm translating from the Latin of the original source there. But the court demanded a yes-no answer. Bullocker, during a longish dispute, would not give one. He stated that no infallibility was attached to the Parliament which set up the law in this way against priests. Therefore what he had done, and which he did not deny he had done, was not constrained to judgment, as he put it. It could not be a crime. All this comes from Bullocker's own account, which was later published in Latin, and that's my translation. His account stopped there. But a non-Catholic news pamphlet published at the time more or less agrees and tells us the rest. The judge observed that Bullocker had refused to be tried by law, and that he had confessed to the act he was charged with while doing so. The court records tell us that Bullocker refused to plead and was immediately sentenced. Other priests, however, found their sticking point at the next question: how will you be tried? The required answer was, "by God and my country," which meant the jury. However, some priests on trial didn't give it. A chap called Godfrey Morris in 1598, so back in Elizabeth's reign, sorry about the repeated time jumps, pleaded not guilty, but refused the jury. His given reason was a kind of charitable concern for the jury. He did not want them to be guilty of his unjust death. When they gave a reason like this, prisoners were basically saying that jurors would be obliged to convict, fair or not, and would thus be complicit in shedding innocent blood. This, of course, underlined the injustice of the law itself, otherwise there would be no guilt involved. It also accused judges of abusing the whole system of jury trial by coercing verdicts. Mark Barkworth, in the year 1601, also claimed this. "These men be ignorant," he said, "and unlearned, simple souls. They shall never be guilty of my blood, for I know they must condemn me." Now, the interesting thing about Mark Barkworth, though, is that his defiant rejection of trial, knowing this meant an automatic death sentence, followed a long process during which he had been questioned many times and kept refusing to admit he was a priest and kept insisting that his enemies had to prove his guilt and that they couldn't. We know a lot about Barkworth's case because he helpfully wrote it all down for us, which is not as unusual as you might think. So I'm going to spend a bit of time looking at his case as he described it. Barkworth, writing to a friend, carefully detailed a whole succession of interviews with regime officials, including 2 occasions when he was brought to the court and questioned by a judge, but not formally arraigned, so not put on trial. And Barkworth makes quite a point of how he never gave them a case. They asked, "Are you a priest or not?" I answered, "I am as I am, prove it." And maintained this insistence that the charge was for them to prove for a good 8 months. And Barkworth had a certain amount of fun winding up his opponents. "Thou art," quoth Sir William Wade, "an idolater, and thou shalt be hanged for a priest and a traitor." Barkworth retorts, "I am a better subject than any heretic in England, and will prove myself as good as you." "Thou art a priest," quoth he. "Then a better man than yourself," quoth I, and so I put on my hat and sat down, whereat Mr. Wade was much offended. Now, wearing your hat or taking it off, standing or sitting, these were marks of social rank. You took off your hat before someone significantly higher ranking than you. You kept it on with your equals and those lower down. Obviously, a prisoner being questioned by an official would be expected to uncover his head and stand respectfully. So when he put on his hat and sat down, Barkworth was asserting the status of priesthood vis-à-vis secular high rank, while Wade insisted that being a priest made him an outlaw. Barkworth also spent some effort, he tells us, discrediting the witnesses who were supposed to prove he was a priest as unreliable perjurers. Now, acquittal on this priesthood charge was highly unlikely, and most defendants knew it was. Yet hoping to set that precedent shouldn't be discounted as a reason for mounting a careful defence. And I wonder whether Barkworth did, in fact, hope to succeed. What we have to remember here is that the persecution of Catholics was not a constant state of savagery. It waxed and waned depending on circumstances, including the politics of the moment. And at this time, 1600 or so, some Elizabethan politicians may have been toying with offering lenience to some Catholics, in effect favouring some Catholic factions which were actually locked in disputes with other Catholics. Perhaps it was thought Barkworth might be useful in a project to divide, conquer and tame the Catholic minority. And he had reason to hope less that he'd win a trial than that he might never be legally charged. On one occasion he claims a letter from the powerful Sir Robert Cecil actually halted his trial. This is possibly why he told Wade that, in despite of you, I will get out. Which must have been really provoking to Wade. But in February 1601, the politics changed, or the politicians realised Barkworth wasn't going to be useful to them. Barkworth ended his letter to his friend with this statement: "I was able to disprove them all to their utter confusions, Wherefore I wish all Catholics to behave themselves very circumspectly, and to take heed how or what they answer, and what they confess. It is good to take a course that heretics may not have their wills. But unfortunately he had to add a postscript, explaining how on the 23rd of February 1601 he had finally been arraigned on the predictable charge, and left court a condemned man. He was executed a few days later, but obviously someone else wrote up that bit. And this was when Barkworth's strategy changed. He had one last fling, a thoroughly legalistic challenge you could make at arraignment that the indictment wasn't properly drawn up, they had his name wrong, and other details. These mistakes corrected, Barkworth was asked, "How will you be tried?" and refused the jury with his answer, "By God, his blessed apostles and martyrs." Barkworth at trial seems to hover between using the system and defying it. He had, during the whole process, at some point invoked pretty much every different approach to the legal process which I've ever come across a priest deploying. In a way, this plethora of arguments decreases their strength overall. It's as though Barkworth couldn't quite make up his mind. It might have come across better to pick one line and plug it with grand simplicity. At one point, the judge, not unprovoked, told him that he loved the sound of his own voice, or in his words, "Thou dost love to hear thyself speak." As it was, Barkworth, once it became clear that he was never getting off, had no reason not to defy the system altogether. And he suddenly starts talking about martyrdom. "I neither fear your profane laws nor your tortures, for they shall be unto me more sweet than honey," he said. Yet it's as though he couldn't quite let go of his longing to show his oppressors to be legally as well as morally in the wrong. As the judge instructed the grand jury to pass all the indictments on to trial, Barkworth had to interject again, "The indictments be erroneous and wicked." This charge shouldn't even make it to trial, and, he repeated, he hadn't submitted himself to the jury. That afternoon, offered one more chance to submit, Barkworth again insisted that "you do proceed against me without any law in the world." Yet he knew that his choice to refuse trial must lead to the death sentence, and declared, "I am more willing to die for my faith than ever I desired to live, and I can never die better than for that truth for which my Saviour died." And so, wrote Barkworth, "Then the recorder, having nothing else against me but that I was a Catholic, gave cruel sentence of death against me, that I should be half hanged, the secrets of nature to be cut off, and my neck by the shoulders, my entrails to be burned, my head and quarters to be set on poles. Which sentence when I heard, I thereat smiled, making the sign of the cross, and rejoiced, saying, Te Deum laudamus, Te Domini confitemer. We praise thee, O Lord, we trust in thee." And so I thanked the recorder. Thus I pleaded against them out of their own laws, so that they could not find me guilty by law, yet nevertheless I am condemned to a most cruel death. Since Barkworth had refused trial in a treason case, automatic sentence was the legal consequence. But yet it was important to him to insist that the charge against him was bad in law. It mattered to some Catholics to maintain that their enemies attacked them against English law, as well as against God's law. Barkworth chose the moment of trial to change strategy. But a lot of priests pleaded not guilty, accepted trial, and then demanded that the Crown prove its case, conducting apparently determined defences, as they disputed evidence, cross-examined witnesses, etc. I'm now going to explore some accounts of those defences. Now, it's important to clarify that at this time there was no defence counsel in criminal trials. The prisoner examined witnesses, responded to their evidence, and spoke for his or her own innocence. One trial for which we have a decent amount of detail was George Fisher's. Again, he wrote it up himself. He was tried in 1629, when Charles I was on the throne, and to be honest, Charles preferred to limit the persecution of Catholics to extorting money and sometimes locking them up. He avoided executing them. At Fisher's trial, the judge asked him outright if he were a priest, something which Catholics kept saying they couldn't lawfully do and which judges kept doing. Fisher took the stance that no one was obliged to accuse himself and would not answer. I answered that I was not to accuse myself in that place. Judges had been known to take this refusal as evidence of guilt and instruct juries to convict, while Catholic priests kept insisting that their silence wasn't evidence. In Fisher's case, however, the Crown presented a witness, a chap called Pendering, who swore that he had heard the defendant say Mass and hear confessions. Now, this would seem like case-closing evidence. But Fisher challenged him. Had he absolved Pendering himself of any sins? Could Pendering actually name anyone Fisher had absolved? Pendering could not. As for saying Mass, I asked him where he had seen me say Mass. He answered, in mine own chamber and Mr. Fisher's. Then I asked him what Mass was. He knew not what to answer. Then I turned to the bench and told them he was so ignorant that he could not distinguish betwixt saying Mass and other prayers, and that I did as it was fit. He testified again that I had said Mass and that I knew it well enough. Fisher pointed out that it's not about what I know, is it? It's about what you know. Or in his words, I bade him to shift upon his own knowledge and not upon mine, and so did the king's attorney call unto him to testify what he knew himself. Then he turned unto me and bade me begin Mass, and he would answer me, whereupon all laughed heartily. And now Fisher pushed his defence even further. I told my lord that saying of Mass did not convict a man to be a priest. What if he was just masquerading? He told me no. I told him yes. I had known some punished for so doing. That is, I think, he had seen such fraud punished in Catholic countries. He said they were wicked men, that I would not confess myself to be such a man, and, crucially, that it was enough to prove that I was a priest, for that I would not deny it. I told him indeed I did not deny it, but that was no sufficient proof of it. It didn't work, of course. The king's attorney told the jury they had evidence sufficient, and they duly convicted. George Fisher was condemned to death, but actually spent the next 12 years in not very strict imprisonment, and in 1641 he was allowed to leave the country to become president of the Catholic English College at Rouen, because that's how Charles I's infamous tyranny worked. He died in 1645, so running the seminary was actually more swiftly lethal than being condemned for treason. But what was the reason for the kind of dogged defence Fisher is an example of? His arguments may seem to border on absurdity, but he was really taking the logic of the burden of proof to its conclusion, and he was insisting on a precise application of the statute. The offence was receiving Catholic ordination overseas and then returning to the realm. Therefore, explicit witness testimony of that event was required for proof. Evidence that the prisoner had done things which he probably wouldn't have done unless he had committed the offence, well, that's just inference, isn't it? So, these are some examples of the different ways Catholic dissidents responded to what they believed was bad law. But what does it mean? Why did some priests behave like Fisher, and others like Edward Jones or Mark Barkworth? Well, like all religious dissidents, it is about the difference between authority and power. The state has no right to require you to break God's law. But what authority does it have? These legal debates then become linked to questions of allegiance, of political loyalty. Now, English Catholics might hold a range of beliefs about the authority of the Elizabethan state. One might regard Elizabeth as a heretic and usurper who had been declared so by a pope, Pius V, in 1570, and whose rule therefore had no authority. Or you might accept her authority as lawful in itself, but these particular laws as invalid because they went against a higher law, that of God. Or there was the extreme view that one should always obey God's law, but the prince had a right to order whatever physical consequence for this, including vivisection, that she or he chose. Offering a legal defence would seem less defiant than the refusal of jury, which challenged the state's authority more profoundly. These legal choices don't always line up neatly along a spectrum of allegiance, though. For example, in 1588, the priest John Weldon had, when questioned, taken the loyalist stance that he would defend Queen Elizabeth against any invasion of Catholic forces, even one endorsed by the Pope. He still refused jury trial, and he was still executed. And it is interesting that no Catholic in a courtroom rejected the Protestant state's authority per se. English Catholics disputed the legitimacy of statutes, the fairness of jury trial, or the principles of proof and evidence, but no defendant argued that the Protestant state was simply unlawful and therefore could operate no true parliaments, true statutes, or true judges, and this was simply not a court. So what was the value in offering these dogged yet almost certainly hopeless legal defences? There were a couple of reasons. One was that while Christians praise martyrdom, suicide is sinful. Therefore, it was a duty to do everything that wasn't actually wrong, that wasn't actually denying your faith, in order to stay alive. Secondly, and we see this with Mark Barkworth, there was a wish to show your oppressors breaking their own laws. This emphasises the sense of tyranny. They make unjust laws and then operate them even more unjustly. But there was also Catholics' wish to put their Protestant judges, not themselves, outside English law. Men like George Fisher defended what they believed were their rights as English subjects. And for dissidents, defending oneself within the law was not fundamentally self-defence. They were innocent because they were right. The question was whether English law opposed or supported their just cause. Legal defences are a defence of the law. If the nation's law does not convict those whose cause is just, the nation's law is not against justice. Priests on trial who refused to just say, "Guilty, but I was right," were defending the justice of English law. And this was why dissidents' engagement with the law, however clearly designed against them, mattered. It was about nation as well as about religion. It was a refusal to cede ownership of England.